South Carolina has a landlord-friendly late fee framework with a limited statutory provision that provides basic guidance while giving landlords broad discretion. The governing law is found in the South Carolina Residential Landlord and Tenant Act, South Carolina Code Title 27, Chapter 40, along with general contract principles. If you're a landlord or tenant in South Carolina, the statutory framework provides a foundation, but the lease governs most of the details. Let's start with the key provision. South Carolina does not impose a specific statutory dollar cap or percentage cap on late fees. However, under the South Carolina Residential Landlord and Tenant Act, the general principle of reasonableness applies. Late fees that function as penalties rather than reasonable estimates of the landlord's actual damages from late payment can be challenged as unenforceable under South Carolina contract law. South Carolina does not mandate a grace period by statute. There is no state law requiring a specific number of days before a late fee can be charged. If your lease says rent is due on the 1st and a late fee applies on the 2nd, that's enforceable. However, standard practice among South Carolina landlords is to provide a grace period of 3 to 5 days, and many property management companies use 5 days as the default. The reasonableness standard in South Carolina is evaluated under general contract law principles. A late fee is treated as a liquidated damages provision, enforceable if the damages from late payment are difficult to calculate precisely, and the fee represents a reasonable pre-estimate of those damages. A fee that is grossly disproportionate to the landlord's actual costs is vulnerable to challenge as an unenforceable penalty. What's reasonable in South Carolina? Industry standards and typical practice suggest that a flat fee of $25 to $75 or a percentage-based fee of 5 to 10% of the monthly rent is generally defensible. South Carolina's rental market ranges from expensive coastal markets, Charleston, Hilton Head, to very affordable inland markets, and the fee should reflect the local rent level. In Charleston, where rents commonly range from $1,500 to $2,500, a fee of $75 to $150, roughly 5 to 8%, is typical. In Columbia, where rents are more moderate, fees are proportionally lower. In smaller communities with rents of $500 to $800, a flat fee of $25 to $50 is appropriate. The lease must clearly state the late fee terms to be enforceable. The lease should specify the rent due date, any grace period, the exact fee amount or formula, when the fee is triggered, whether additional charges apply for continued non-payment, and whether the fee is defined as additional rent. A late fee that isn't documented in the lease is difficult to enforce. South Carolina courts expect written agreement on fee terms. Compounding late fees in South Carolina are governed by the lease and the reasonableness standard. A single one-time fee after the grace period is the simplest and most defensible approach. If your lease imposes daily or weekly charges for continued non-payment, the total accumulation must remain reasonable. A compounding structure that could produce total fees exceeding 15 to 20% of the monthly rent is increasingly vulnerable to challenge. The interaction between late fees and the eviction process in South Carolina is governed by the Residential Landlord and Tenant Act. Under South Carolina Code Section 2740.710, the landlord can issue a 5-day demand for non-payment of rent. If the tenant fails to pay within 5 days, the landlord can proceed with eviction. The amount demanded must be accurate. Whether unpaid late fees can be included in the 5-day demand depends on how the lease defines them. If late fees are defined as additional rent, they can be included in the total amount. If treated as a separate charge, they may need to be pursued independently. Best practice: define late fees as additional rent in your lease. South Carolina's eviction process through the magistrate court is relatively fast compared to many states. The combination of the 5-day notice period and efficient magistrate court proceedings means that chronic late payment escalates to eviction quickly. Late fee provisions interact with this timeline. Ensuring your fees are compliant avoids complications in an otherwise streamlined process. South Carolina does not have a specific statutory cap on security deposits under the Residential Landlord and Tenant Act. Standard practice is 1 to 2 months' rent. The deposit must be returned within 30 days of the tenant vacating. Unpaid late fees can be deducted from the deposit if the lease authorizes the deduction and the fees are reasonable. The landlord must provide an itemized list of deductions. Failure to return the deposit within 30 days can result in liability for up to 3 times the amount wrongfully withheld, plus attorney's fees. So getting the late fee deductions right is important. For tenants receiving Housing Choice Voucher Assistance, South Carolina landlords should not charge late fees when the housing authority's portion is delayed due to processing. The tenant cannot control the authority's payment timeline. If the tenant's portion is paid on time, the late fee should apply only when the tenant's own payment is actually late. South Carolina's substantial military population affects late fee dynamics across the state. Joint Base Charleston, encompassing Air Force and Navy operations, generates significant rental demand in the Charleston metro. Fort Jackson near Columbia is the Army's largest basic combat training installation. Marine Corps Air Station Beaufort and Parris Island generate military demand in the Beaufort area. Shaw Air Force Base near Sumter generates demand in the Sumter corridor. Military pay arrives on the 1st and 15th, predictable and reliable. Most military tenants pay on time. When late payments occur, they're typically related to PCS transitions or deployment disruptions. The standard 3 to 5 day grace period accommodates most of these short delays. Landlords near military installations should understand SCRA protections that may apply to service members experiencing financial hardship. Fort Jackson's training mission creates a specific dynamic. Trainees' families who relocate to the Columbia area may be adjusting to military pay schedules for the first time, and the first month's payment may be delayed while allotments and direct deposits are established. Some landlords near Fort Jackson build this expectation into their onboarding process. From a practical standpoint, South Carolina has one of the fastest growing rental markets in the Southeast, and late fee dynamics vary by market. Charleston has emerged as one of the most desirable markets in the region. The economy is driven by Boeing, the Port of Charleston, Joint Base Charleston, healthcare, including MUSC, tourism, and a growing tech scene. Charleston's professional tenant base generally pays on time. Late fee enforcement is limited to a small percentage of tenants. The strong market means landlords can screen for payment reliability. Columbia, the state capital, has a diverse market driven by state government, the University of South Carolina, Fort Jackson, and healthcare. Student tenants near USC may experience late payments at the start of each semester when financial aid is processing. Fort Jackson families may need accommodation during initial pay setup. The broader Columbia market has moderate late payment rates. Greenville has experienced remarkable growth with strong demand. The professional tenant base, driven by BMW healthcare and a revitalized downtown, generally pays reliably. Late fee enforcement is standard but not a dominant operational concern. Myrtle Beach and the Grand Strand have seasonal workforce dynamics. Tourism sector workers may have irregular income patterns, strong during summer, reduced during off-season. Late payment rates can increase during the slower months. Some beach market landlords adjust expectations seasonally. Hilton Head and Beaufort have unique dynamics. Hilton Head's resort economy creates seasonal payment patterns, while Beaufort's Marine Corps presence produces reliable military tenants. Spartanburg, Rock Hill, Anderson, Florence, and Sumter have more moderate markets with varying late payment rates. Sumter, near Shaw AFB, has a military-influenced market with generally reliable payment patterns. Clemson, home to Clemson University, has a tight student market where financial aid timing affects early semester payments. One best practice for South Carolina landlords: set your late fee at a level that reflects your actual costs and the local market. In Charleston's premium market, a fee of 5 to 8% is standard. In more affordable markets, calibrate the dollar amount to the rent level. A fee that's reasonable in Charleston may be disproportionate in a smaller community with half the rent. Another best practice: include a grace period of at least 5 days, even though South Carolina doesn't mandate one. A grace period is standard industry practice, demonstrates good faith, accommodates minor delays, and makes the fee more defensible if challenged. 5 days is the most common standard across the state. A third best practice: document every late payment and every fee charged consistently across all tenants. South Carolina's military communities are diverse. The tenant population near Fort Jackson, Joint Base Charleston, MCAS Beaufort, and Shaw AFB includes service members and families from every background. Consistent enforcement across all demographics prevents fair housing issues. Keep records of dates, amounts, grace period calculations, and communications. For the complete guide to South Carolina late fee laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our late fee law series.